Starting over. So it's recording in progress now. Good morning, everyone. Welcome to the 2025 Forms Updates course presented by the Oregon Realtors. I know some of you were expecting Nick Peasley, Oregon Realtors staff attorney, to present today. Well, we've had to pivot slightly, all for good reasons. Nick and his wife had a baby in the middle of the night. I think they were expecting within the next week, so it's not early. Everything's great. His wife gave birth to a healthy baby boy, Finnegan. So thankfully, one of our fabulous practitioners that has been instrumental in drafting forms and being a part of the conversation was available and willing to step in to help this morning so we could continue with this webinar. So I'm really pleased to introduce, for those of you who don't know, Linnea Miller. She is a principal broker from Central Oregon. She has a long storied career in the real estate industry. In 2010, she opened Ben Premier Real Estate, which is, for those of you from the area know, is a highly respected, independent, locally owned brokerage with over 70 agents. And Linnea, you may have more than that now, 70 brokers. She's been very involved at the state level, chairing business issues committee, been part of the forms drafting process. She's done a number of things, government affairs. She's touched it all here at the state level. And on her local board, she not only has done a lot of law and policy related stuff, she's also, which of course includes multiple MLS stuff. I don't know if you've done advocacy on the local level, but Linnea is very familiar with everything related to association and industry work. And without further ado, I will let Linnea take it over. And thank you so much for pinch hitting for Nick today. I mean, you are a fabulous substitute, and welcome. Thank you, Linnea.
Thank you, Jenny. Hope everyone can hear me well. Obviously, I'm not an attorney, and so if you have any sort of legal questions that may come up during the course of this presentation, please put them in the chat, and we'll make sure that attorneys get back with you on those. I also want to remind everybody that not to put anything into the chat that would be misconstrued as antitrust. Also, great resource, orforms.org. That is where our forms are found. That is also where you can always contribute any sort of comments or suggestions for Oregon Realtor Forms. Remember, Oregon Realtor Forms are your forms. They are put together by the state association and our task force in conjunction with our state attorneys, but they are the forms that are designed to work for you. And so whatever needs you have, if you see something that's missing, feel free to please contribute and let us all know what that is. So moving forward, to let you know about the 2025 updates. Again, the updates come from several sources. User comments, which I just mentioned, orforms.org. Put your comments in there. There's also the Forms Forums and the Principal Broker Forums. And if you've never attended these, they're at our spring and our fall governance meetings. They are wonderful, wonderful forums to hear directly from the attorneys and other managing brokers and other participants who have comments and ideas about the forms, and to obviously contribute to things that they think work that don't. Also, the Forms Task Force, which I've been serving on for quite a few years, we give our own comments there, and based upon our own experience. For me, as a managing principal broker, I hear a lot what's going on with our staff and our agents, and I obviously incorporate things that I think are working well or things that are not working well that need to be updated to the task force. And then, of course, attorney reviews. Anytime there's a change in state law, anytime there's a change to an Oregon statute, those all need to be incorporated into our forms. And of course, that is how that happens. So there are 3 forms with major updates. They are the Form 2.10, the Contingent Right to Purchase Addendum, Form 4.4a, which is the Delivery and Receipt of Association Documents, major change there. And brand new form, which it's unfortunate that we have the need for this, but it's coming up, Form 4.5, the Short Sale Addendum. And for those of us who lived through the housing crisis, we know how important those addendums were, and how that was such a major component of our business. Hopefully we'll never get back to that state, but it's important to have that in our forms library. Now, there's also forms with minor updates, forms 1.1 through 1.5, which are the sales agreements, minor updates in there, but we will go over those. There's also Form 2.11, Notice of Intent. Also Form 4.4, the Association Addendum. Form 9.3 to 9.4A, representation and non-agency agreements. 9.11, the referral agreement, and then of course the advisories, 10.1 and 10.2. I forgot to mention that Kelly from Oregon Realtors is monitoring the chat. And if you have questions as we go through the this presentation today, please put it in the chat, and Kelly will interrupt the presentation to pass on any sort of chat information or chat questions that you may have. And there's also a section at the very end for you to put in your questions. Moving on, let's talk right away about the contingent right to purchase addendum. So everyone understands that if the buyer for a property has to sell a property in order to perform on their purchase, they have to utilize this form, the contingent right to purchase addendum. So understand, it's made clearer now that if the property that the buyer has to sell in order to perform on the purchase is in contract, there's no purpose to Section 4 of the contingency deadline, and the form has been modified to reflect that. So in other words, their home that they need to sell is already in contract, it's already in pending status. So in that case, the seller of the property they are purchasing should put their property, once we have a ratified contract, in pending status in MLS. And this form clears that up a little bit. Now, the major change that we've had in the contingent right to purchase addendum is that all timelines would start upon ratification of their purchase, ratification of the contract for their purchase. Now we have boxes to check regarding due diligence and appraisal deadlines. So on line 62, the due diligence period to begin upon mutual acceptance of the sale agreement. And again, the appraisal deadline shall state as in the sale agreement. So in other words, if your buyer does not want to put out any money in due diligence, no money in a home inspection or in an appraisal, then you would check that box in line 62, so that it will not, the due diligence period will only start upon notification that the buyer's home is now in contract. Or on line 65, the buyer is going to go ahead and start their due diligence immediately upon ratification of their purchase. So the motivation for a buyer to do that, of course, would be if they want to show the seller that, yes, I know I still have to sell my home in order to perform. However, I'm going to put my money where my mouth is. I'm really motivated to purchase your home. And so I want to go ahead and get going right away on the due diligence. I want to get that done. Also, in the case of a multiple offer situation, and the contingent purchase is always a weaker purchase than one which does not have that contingency. Obviously, someone would want to show, I'm really motivated and I want to go ahead and get going on this and get my due diligence started right away. So that's a major change here. Again, allowing the due diligence period to start upon notification that the buyer's home is now in contract. Okay, another major update is Form 4.4A, delivery and receipt of association documents. A major change is that this change is so that when people will say, here's the checklist of all the things we need to provide to the buyer regarding the association of the seller's property, if those documents don't exist, there's a box now to check to say they do not exist. So taking a look at that a little bit further, this is the Form 4.A, delivery and receipt of the association documents. So you can see this brand new thing, a box to check that they've been delivered or that the document does not exist. Now, if I was representing a seller in an HOA, I would let them know about this document right away. And I would suggest when I take the listing, please fill this out. Let us know what documents do and do not exist so that upon getting your home into contract, we can let that buyer know right away that these things do not exist. So it's really important, obviously, when you're representing a buyer in a property that has an HOA, that full disclosure happens on everything that's going on with the HOA. It's very important. And so here, this document will allow for notification that they have been delivered or they do not exist. So it's just one of the new changes and new tools so that the buyer has full assurance that they've received every document that may pertain to this property, and that they are fully informed moving forward on their purchase. Now, the new form, the short sale addendum. And again, we all understand that in a short sale, that the transaction will require lien holder approval of the short sale. And again, a short sale is used to describe the sale of a property where the purchase price is or maybe less than the mortgage on the property, the liens on the property, including mortgage loans, credit lines, judgments, construction liens, taxes, all sorts of things. It's one of those unfortunate things that may happen to someone who gets under financial distress. This is an addendum so that we can move forward on a purchase so that the buyer understands what they're getting into when they purchase a home that is in a short sale, in which the purchase price is less than the legal obligation of the seller to pay back creditors. So in a short sale, there could be several lien holders who all need to sign off the sale. They are not obligated, nor is it guaranteed that they will sign off the sale. Understand that even though the seller may accept the purchase price and accept the agreement, it's subject to lien holder approval. So that's really, really important for disclosure to the buyer. It's also important that the seller understand that, you know, we still have to get, even though I like this offer that's received, I'm selling short. And so the people who have the liens on my property have to approve this. And also that when the lien holder approves, all approve, the seller has the ability to approve the terms and tell the buyer about it. So if the seller doesn't approve the terms, the buyer has an endless right of termination. So in other words, the seller has to say, I agree to the terms that the lien holder or holders have on the property to grant my short sale, but also the buyer has the right to back out. If the deadline hits without approval, everyone can back out of the deal. And understand that in a short sale, there could be multiple lien holders, and there's no assurance of lender approval. The parties understand that a lien holder is not obligated to accept the short sale. They may initiate or continue a foreclosure proceeding after granting approval of the short sale. They may request a copy of any offer the seller receives. They may require modification of the contract terms and the seller's agreement to personal guarantees of debts, seller's agreement to a promissory note, seller cash payments, or other obligations at the lien holder's discretion. The seller and seller's agent are not liable for delays or failures caused by lien holder or any costs, expenses associated with lien holder's delays or failures. And that liens held by the FHA or guaranteed by the VA may require seller's payment of any amount forgiven. So those of us who dealt with this in the past understand short sales can take a long time, especially if there's a first and a second, and in some cases it can even be a third. You have to get approval of the primary, the second lien holder, and then sometimes there's other things that may pop up. Personal story, back during the short sale and financial crisis when we were dealing with this, our brokerage represented a buyer in a short sale. It was a great property that he was very motivated to purchase. He was a cash buyer, which was unusual during the financial crisis, but it was a cash buyer. And the seller had, I think, a first and a second on the property. Now, the listing agent did a great job in getting the first and the second approved. And we got, upon approval, that's when we would start all the due diligence period and all that sort of stuff. So the inspection and everything, we got through everything. So we were about a week off from closing, and then all of a sudden a new preliminary title report was delivered in which a personal judgment against the seller popped up of $10,000. Our buyer was motivated to close on this property, so said, rather than trying to get this personal judgment removed and finding a way of getting them to accept, a pittance and getting the primary and the second mortgage holders to agree to this pittance going to the personal judgment, our buyer agreed to pay off that $10,000 judgment himself as part of his purchase agreement. The day of closing, another $10,000 personal judgment popped up. And in that case, our buyer again was motivated to say, hey, I don't care. I want this property. It's the day of closing. I already got my moving truck ready to move in, so I will pay that as well. So upon closing, and we successfully closed. So upon closing, that seller had their first and second forgiven, basically. And then those two personal judgments paid by our buyer. And it was a win. Our buyer paid $20,000 more than they had anticipated, but that's the nature of a short sale. You never know till you actually close what's going to happen. So there's no assurance of lender approval. There's no possible, you may even find you have to modify your purchase up to and including, in our case, the day of closing, but it was successful. So these are things, and I hope we never get back to that level of dealing with this, but having this new form in our library is going to be extremely helpful. So there's two other boxes to look at in the short sale addendum. One is here about continued marketing. If this box is checked, the seller may continue marketing the property as an active listing. So understand, I mean, I know in our MLS here in Central Oregon Flex through Oregon Data Share, we have a box that was very used during the financial crisis, approved short sale. So in other words, people knew that more offers could be offered. And that's usually in the best interest of the lien holder to the property because they want to get more offers. They want to accept and they want to move forward on the best offer for that property so that their debt that they're forgiving is lessened. So if this box is checked, understand that the buyer understands the seller is going to keep on marketing it as an active listing until approved by the approval notice is given to the buyer. And then also here on line 54, if this box is checked, the seller may accept backup offers to purchase the property conditioned upon termination. So in this case, it would be one or the other. So if this box is checked, seller is going to continue marketing the property, and this may be mandated by the lien holder of the property. And also line 55, foreclosure. Seller represents that to the best of seller's knowledge, a foreclosure proceeding has been filed or has not been filed. Now, most lien holders do not want to foreclose on the property. It's expensive for them. They have to deal in a traditional foreclosure with right of redemption. They can't sell their property. They're not motivated to hang on to real estate. They don't want that. They would much rather get rid of this property, get it off their books. So has it been filed? Most likely the process gets started when a notice of default gets sent to the owner of the property. But that starts the foreclosure process. But if the seller contacts their lien holder and said, look, I'm willing to short sale, I want to get this property off the books, most lien holders will delay the foreclosure. That's been our experience in the past. So again, generally lenders want to keep the seller marketing to find the highest price. And again, lien holders have a lot of power in a short sale. So if you're relatively new to the real estate business and have never dealt with short sales, I advise you to consult with your managing broker, find out their experience, especially if you ever get a listing in which the seller is maybe in a notice of default. Now, there's been a lot of changes in our industry ever since COVID hit. In which the value of homes have gone up tremendously. And if you're dealing with someone who has owned their home for at least 5 years, maybe even less than that, but based upon your individual market, have home values increased since the purchase of that property by your seller, you may find that they have built up equity to a point that even if they're under financial distress and they can't make their mortgage payments, the amount of equity in their home upon sale after paying all their closing costs, they may be able to pay off their lien holder in entirety, including any sort of late payments and fines. And so it would not be a short sale. So have that discussion with your seller and say, look, if you're dealing in financial crisis, you need to connect with your lien holder and find out if they are fine with you selling. We represented one of these during the during COVID, in which our seller had a property that was, and they did not have the funds to pay the mortgage any longer. And as a result, they were dealing with notices of default. But the value of the property, they had about $400,000 in equity, because it had gone up so much since they had purchased their property. And so they were able to delay the foreclosure. We were able to sell the property. They were able to pay off their loan and walk away with all that extra money in their pocket so they could start over fresh. So it was a win for all parties. So just understand that if your client is experiencing that, find out what their, have them contact their lien holder, find out what the lien is, how much do they actually owe, and see if the value of their property is such that they could actually sell without having to deal with a short sale. So that's important to understand that. Okay, moving on to the minor updates. By the way, Kelly, have there been any questions that have popped up in the chat that we need to address right now before we move into the minor stuff?
No questions, just a couple of suggestions or notes on forms that they've seen, and I'll pass those along to the forms team.
Perfect. Thank you so much. Okay. So minor update. This is one of those things, and I'm so happy that this has been addressed. This is very, very important. We start counting business days versus calendar days, and we all know that business days do not involve Saturday, Sunday, and any sort of holiday. There's always been a question concerning state holidays versus federal holidays. And in particular, we've always talked about Columbus Day, because that's been a federal holiday, but not a state holiday. Now it's clearly defined in the sales agreement, all sales agreements 1.1 through 1.5, that a federal holiday is also added as a business, as a non-business day. So be aware that now that one question is clearly defined now in the purchase agreement. So we do not count federal holidays, including Columbus Day. Okay, a minor update, and this pertains more so to those of us, those brokers who utilize these forms in the Portland metropolitan area and are part of PMAR. In line 425, 426, when we deal with dispute resolution, mediation shall take place through the Arbitration Services of Portland, which is ASP, because PMAR, which used to have a mediation program, has stopped it, has shuttered their program. So now that whole section has been crossed off. So in other words, they're no longer dealing through mediation with PMAR. Instead, we're dealing with the Arbitration Services of Portland. Also on line 440, 441, Article 17 of the arbitrations between two or more brokers on things such as open listings are only applicable if the client has agreed to participate in arbitration or requests the arbitration and agrees to be bound by this decision. So this clearly defines this. In the event, it must be exclusively resolved under Article 17, the Code of Ethics, of course, which is duty to mediate or arbitrate rather than litigate the dispute. So it's now clearly defined. A minor update in the commercial listing purchase agreement. And for those of you who deal with commercial real estate, I wouldn't say this is a minor update. I would say this was a very important update. This is one of the things that commercial brokers I've worked with thought was extremely important to incorporate into our purchase agreement. There's now an expiration date for the buyer's offer. For those who deal with commercial real estate, you understand that usually in commercial purchases, there's a lot of due diligence that happens. It can take months, it can even take years, depending upon how in-depth that due diligence is. Now, to understand, we have written into the purchase agreement a date for the buyer's offer to expire is in there. In the past, it was in additional provisions. If you wanted to have your offer expire at a specific time frame, you would write it now there. Now we have it in the purchase agreement. So that way the buyer knows they have a ratified contract contingent upon their due diligence. And like I say, due diligence in commercial, when you're dealing with government entities, when you're dealing with architectural designs, when you're dealing with all the surveys and all the things that you need to do to develop a commercial piece of property, it's extensive. And so now we at least know that the seller has accepted your offer contingent upon your satisfaction, buyer, of your due diligence is now in the contract. Obviously, if that's not something you want, that can be done away with in the additional provisions. But, you know, I think this is a major change and an important thing, even though it's, as far as how the contract reads, it's just a couple lines. Okay, another minor update is just basically a formatting change in the notice of intent. It's visual. So the notice of intent goes both between the buyer and the seller concerning different aspects of a purchase agreement. And now those sections that are pertinent to the seller are noted in that bold line for the seller. And now the sections that are pertinent to the buyer are now defined by that bold line for the buyer. So it makes the page, that addendum, easier to really search through if my notice of intent needs to be addressed by my seller or if it needs to be addressed by my buyer. Just a formatting, a change there. Now there's one other change in the notice of intent, which defines another section for the buyer. So it spells out that one section for the buyer to terminate in its own little section. It's now defined differently, and so it's easier to find it. If your buyer has to terminate, this is now its own line. It's spelt out better in bold. So intent to proceed with the contract, intent to proceed with release, or intent to terminate. I think it makes it easier for the user of this document to really define and find out where I need to check the box. Okay, association addendum. We already talked about a couple of things, but on 4.4 versus 4.4a, 4.4a is where we have the checkbox, remember? But now on the 4.4 addendum, it's spelling out broad things such as the planned community under Oregon Statute 94, the condominium association or under Oregon Statute 100, the Marina Park Association or Manufactured Park Association. So we are just basically defining them per the Oregon statutes for the planned community and the condo association. And, you know, it's one of those things that how they are defined by state statute. And again, we already talked about this a little bit here. Added the null set options for users. So not applicable. So this is again an association addendum, say that the seller owns or leases the following, like a parking space, a storage space, a slip space, a home park space, or if none apply, check here. I always think that's good. Not applicable versus just leaving stuff blank. Sometimes a buyer receives that and said, well, did the seller miss something? You know, is there something that they forgot to check out? Should I check this? Should I send this back to the listing agent so they make sure that their seller fully fills this out? If it doesn't apply, check here. So check that box right here if these things do not apply. Okay, provide now another minor update for 4.4, provide an additional explanation of the use case for does not exist option. So again, if the association documents do not exist, seller shall provide form 4.4a to the buyer and list the documents that the seller is unable to provide in the space that we talked about already. Because again, I think that is extremely important. Anytime you are representing a buyer in any sort of HOA, say the budget. There is no budget. I mean, I can't imagine them not being a budget, but say they haven't updated the budget and your client is purchasing a property in which there could all of a sudden be a special assessment, or there could be a major change in the budget that would increase the monthly dues. It's important for the seller to fully disclose this. And so again, using a does not exist option is really, really important. Minor updates connected with 9.3 and 9.4a, the agency agreements. So the old agency agreements show the broker, the principal broker, and the principal broker's firm. Now, changes made to House Bill 4048 rulemaking. If you don't know what House Bill 4048 was, this was a House bill that passed the state legislature and was signed into law by the governor last year. It had to do with some pretty significant changes to Oregon Realtors, how we conduct our business. And among them was more disclosure. Now, we were waiting for the Oregon Real Estate Agency to take these new law changes and put them into our forms, how we have to comply with it. And among them is putting down the broker's license number. So the license number now needs to be added to the agency agreement. And the principal broker's phone number needs to be added as well. So when you're utilizing these forms for agency agreements, the client that you're working with, be it a buyer or be it with a seller, has the right to now know what the broker's license number is and also the phone number of the principal broker, so they can always easily contact the principal broker if there's questions that they have that they want to go directly to them for. Or also, it's just one of those ways of complying with these changes. 4048, this is a side note here. This was a law that we passed before we had the NAR settlement that mandated starting January 1st of this year, we all had to use buyer representation agreements. Of course, the NAR settlement sped up that period of time. And so we've now been using the buyer representation agreements since August in compliance with the NAR settlement. But now it's now state law starting January 1st. So if you're dealing with any clients who are pushing back on this, we all say it's an NAR settlement. We are realtors. We need to comply. But now we can also say, starting January 1st, it's state law, and we must utilize our buyer representation agreements. It's the law in Oregon, like it's the law in a number of states. But for those who are not used to that before, it's now there. So that's another part of 4058. But again, adding the broker's license and the principal broker's phone number is a way of complying with that as well. Okay, minor updates in the agency agreement is dealing with jurisdiction, minor dispute resolution provision to clarify inconsistency of language. So any matters that are excluded from dispute resolution, again, bringing in Article 17 of the Code of Ethics, seller agrees to arbitrate the issue and to be bound by any resulting agreement or award. So in other words, with Article 17, rather than litigating, we want to go through arbitration and mediation. It's a better method in order to solve issues, and it's less costly for all parties. So again, this is now in our agency agreements. The minor update to the buyer representation agreement. So in other words, the compensation section was updated to clarify that only lines 74 through 76 are non-actionable upon buyer's unilateral termination. Now they reference section 10 below. So in other words, say you're at a point in which you agree to unilaterally terminate, both you as a buyer's agent and your buyer agree, we're not working well together. We just need to go our own way. And we all agree to that. And now the buyer signs a new buyer contract with them. In other words, are they obligated if they enter into contract on a home that you as their previous buyer's agent showed them? Are they obligated to pay 2 commissions? 2 compensation agreements because you show them the home initially. So in other words, if this now says that if the buyer does not have to do that unless they unilaterally terminate. So if they unilaterally terminate, the terms of section 10, which you may have written in a section 10 is where you would write in, if they terminate early, you're going to owe me a fee for my time served. That's a section where you you can negotiate that with your buyer. And that would be part of the thing that when you sit down with your buyer and you're filling out this form to begin with, you're going through, this is my compensation amount, this is the terms of our contract, this is the type of property I will be showing you. And you talk about this, how this works. Say they entered a contract to purchase something, and within 180 days of the buyer's unilateral end of the contract, well, or say that they also have terminated the contract unilaterally. They have fired you, and you didn't do anything to agree to that. That section of Section 10, where you said, early termination, you're going to pay me this flat fee of whatever it is going to be, still pertains. So if you agree to mutually part ways, that's different than if they if they just terminate you altogether. Okay, another change here is the broker referral agreement. So it's optional to do an expiration date on the referral agreement. So when you send out a referral to someone who you're referring a client to, and you're utilizing this form, if this box is checked, the referral is valid for so many dates. You can put it in a date. Typically, I often see these things for a year. Sometimes they're left wide open. Usually the receiving agent, if they're working with somebody for a period of time, even if the expiration date is passed, I mean, it depends on how you do this, but this lets the receiving agent know that I'm obligated to pay the referring brokerage this amount of money for a specific period of time if this person that they refer to me enters into contract during that time. Okay, another minor update is in the buyer advisory. There has been short sale language added to the advisory. So I personally think these advisories are among the most important tools that we utilize for Oregon Realtors. These are phenomenal risk management tools. I encourage everybody to use these regardless of whether or not you utilize the Oregon Library. Even if you utilize another library, you are someone who works with builders who have their own sets of forms. Again, these advisories really help mitigate risk because they do provide to the buyer information regarding what we as realtors can and cannot do, what we can advise in, where you need to, as a buyer, reference these. That means there's hyperlinks in here to reference. Here's someone to check on. If you click on here to check on if you have a question on a certain thing. Again, it takes the risk off of us. We know an awful lot, but we all know we should never step outside of our scope of expertise. We are not attorneys, and we're not experts on preliminary title reports. We're not experts on inspections. We're not experts on the fire code, all these sort of things. So again, these are tools that even if you don't use Oregon Realtors libraries, I really advise that you give them to your seller when you're taking a listing, and you give them to your buyer when you start working with them, just because it's so helpful. And again, one of those great tools that Oregon Realtors produce, and they update regularly. And again, this is a major a minor update, but incorporating the advisory language about explaining what a short sale is. And again, with seller's advisory as well, the short sale language has been added here as well. Again, it better explains this. These are written by attorneys, reviewed by attorneys, these advisories, just to make sure that the information here is accurate and up to date. And just again, tools, get them to sign off on it. I know I have it on the checklist that I use as a managing broker. Where's the seller advisory? Where's the buyer advisory? And if you utilize the Oregon Realtor purchase agreements, all of them have a section at the very beginning which says the seller and buyer acknowledge that they have received the appropriate advisory. And if you use these tools and you don't have the advisory as part of the package you've already provided to your client, that section doesn't work. So it's really important that if you ever use Oregon Realtor purchase agreement, that the pertinent party you represent has the appropriate advisory. I always look to see it's been signed off on, and I always have it uploaded. We use SkySlope. It's always uploaded into SkySlope. Again, risk management tool. And I know I finished really fast. If Nicholas was here, he would have been in much more depth, but if this is questions time. So any questions I can answer, anything, I know we need to go at least another 8 minutes in order to receive full CE credit. So please incorporate any questions that I could answer.
We do have some questions.
Very good.
Let me just go up here. This is in regards to small claims court disputes. So Deborah Williams wants to know, so the parties no longer have the right to go to small claims court if the amount of the loss is less than $10,000?
I believe the way this form was set up, it talks about, no, I don't believe that's the case. I know in Central Oregon that we are obligated to utilize, I mean, the change that they made, where is it?
I was talking to Nick about this because I'm also the professional standards administrator, and we were discussing the change. And I think what it is if small claims is available in your area, then you do. That is where you go. And then
That's always been my understanding here as well, that if the amount of the dispute is less than the small claims figure, like in our case is $10,000, it's handled through mediation and arbitration there. But if it's in excess of that, they want mediation and arbitration in lieu of litigation. So that's my understanding. Again, I'm not an attorney, so.
okay, the next one is from Patrick Eiler. Is by rule or law or just added by forms committee? This is in regards to the buyer representative agreement.
Rule or law?
Hmm.
The buyer contract, is you talking about that, the buyer contract?
You know, and there's maybe, Patrick, there we go. Language in section 8 modified to make clear the holdover provision only applies if buyer unilaterally terminates.
Yes, that's the point of it. So the buyer unilaterally terminates. Your right to collect whatever you had written into section 10, where you say early termination, I'm going to get paid a certain figure that you've already negotiated with your buyer. That still pertains. So the buyer terminates unilaterally your contract. So whatever you filled in with section 10, you said, okay, you obviously, buyer, you have the right to terminate, but I still need to get paid per the contract we have in which you agreed early termination gives me this figure, whatever it is.
His question is, so is the change by rule or law or by our forms committee?
It's by, I don't believe there's any Oregon statute to that. It's the contract that was written with use of the attorney, Oregon attorneys.
All right, let's see. The next one is, I thought it was generally regarded that 2 years is the max for listings and or the amount of days after a listing expires when the seller would still be obligated to pay a commission. Is a buyer viewed the property during the active listing? Wouldn't it be a good idea to have a maximum deadline for paying a referral also?
Well, that sounds like something that should be addressed as a question to go to the forms committee for discussion with our attorney. And that's true. I do know that part of the change in Oregon law, House Bill 4058, is that any listing contract can only be for 2 years, no more than 2 years. And so the same thing should pertain also to buyer contracts. So we need to make sure that, yeah, anything like that, anything longer than 2 years should be addressed. Yeah.
Okay, adding that to my list.
Yeah.
Cheryl Clune says she loves your style and speed of teaching. Thank you.
I go fast, I guess.
I think that was great. It's great. Andrew Bryan, can you run back through the buyer's representation change one more time?
Sure, let's go up there. here. We go. Okay, so it's a minor update here. So we're talking about the agent shall be entitled to commission or flat fee if any of these things happen during this point in time. Again, the compensation section was updated to clarify that only lines 74 through 76 are non-actionable upon the buyer's unilateral termination. So in other words, this section here, if the buyer enters into an exclusive buyer representation agreement with a subsequent duly licensed real estate broker or principal broker after expiration or mutually agreed upon termination of this agreement, an application of this agreement would result in buyer paying more than one commission or flat fee. No flat fee will be due under this agreement. The preceding sentence does not apply if buyer unilaterally terminates this agreement before the end of the term, which is governed by section 10 below. So in other words, the buyer unilaterally terminates the contract. And you have section 10 where you're entitled to receive early termination fee if you've negotiated that, whatever that is. So say that the agent shall be entitled to commission. The part of the concern that we had was that the buyer, most people have a seller contract in which upon termination, the seller enters into a new contract with a new agent that they're not entitled to pay 2 commissions because they've terminated, the old contract is dead. And so the new contract gets into place, and then all of a sudden the buyer who saw the property under the old contract is interested in buying with a new contract. The thing is that the seller only has to pay one compensation at that case in time. So in other words, if the agreement would result in the buyer paying more than one commission or flat fee, no commission or flat fee would due under this agreement unless the buyer unilaterally terminated this agreement before the end of the term. And the terms by which they can do it is in section 10. Kelly, I think it would be important if Nicholas would put out something in maybe the newsletter to fully explain this well enough, because it is a little confusing.
Have that.
Other questions?
We have more. Let's see. Do you have to have advisories newly signed with repeat clients every time, or can you have their advisory on file?
If you have, say you've got a signed advisory with your buyer for a specific property, and now that property didn't get to come together, and now they're going to be looking at another property. I have always used the same advisory. We just move it from one file to the next, unless there's been a major change in the advisory, such as now we have the short sale section in there. And so I think it would be important with the new form to incorporate that with a new purchase for your client. That's me just talking, but the signature should pertain to multiple properties.
Okay. In your practice, how much are you including for an early termination fee?
Oh, that's a great question, and I've got to be very careful about doing anything with conflict of interest and antitrust. I discuss it with our agents, and I say, if you wish to utilize this, I don't dictate anything specific. It's all it pertains between each agent and their client. In some cases, I say you're worthy of everything. You explain your worth. We have a great buyer's representation presentation that we use, which outlines all the reasons why we are worthy of our fee. We developed this last year with the NAR settlement, outlining an awful lot of things why we are worthy of getting paid. And I say, upon your work with your client, when you're sitting down and filling out this contract, you say, look, these are all the things I do. I do a lot for you, and recognize that if we decide, or if you decide to unilaterally part ways, you have every right to do so. but I will probably have spent this many hours working on your behalf. I mean, it could be hundreds of hours working on your behalf. I could have shown you all kinds of homes, and I don't get paid until we actually have a closing. So if I've worked hard on your behalf and you've gone your own way unilaterally, this is what I need to get paid based upon, my worth, my professionalism. But I never give them a specific figure. It's up to them based upon their negotiation with their client. So if they've done a great job in their buyer representation presentation, and they've shared with them, people say, well, of course you're worthy of that. I mean, if I went with an attorney, I would expect to pay a retainer, of course, so it just depends on each agent. Again, I don't dictate this specifically, but I highly encourage. Just like when you're filling out the buyer representation contract and you're filling out, this is my fee that I work for, and you explain this is my fee, and you explain how we will be asking the seller to pay this in the purchase agreement. But understand that if they don't agree to this fee, this is what I get paid. Or if they agree to a lesser amount, you pay the difference. And so and I have agents who are successfully negotiating very, very good fees because they're explaining their worth. So much of it has to do with, do the buyers trust them? Do they come across as professionals? Do they come across as someone who really understands the market and they know what they're doing? And so that's a lot of training. And it's also being able to again, explain your worth. And so, again, I don't have a specific figure, but this is what I say. What's it worth for you to drive people all around, in our case, Central Oregon, showing property in Prineville and in Madras and Lapine? What's the cost of your gasoline? What's the cost of your professional worth in explaining things, all the research you do? So you explain this to them, and then they shouldn't have a figure. They shouldn't have any issue. And another thing, this is a side note, but when people question whether or not, well, I just met you, why should I fill out one of these things? And then you explain to them, look, this is not only NAR settlement, it's also law. But I know we've just met each other. So let's set our contract up for just a short period of time, just a couple of days. And if either one of us decide we're not working well together, after 2 days, this contract's expired and we're gone our own way. But after 2 days, we are finding we're working well together. We're going to modify that with Form 9.4A. And then you could really expand on that figure there for early termination. So I think it's really important is how well you present yourself. So that's a long answer. That's a Nicholas sort of answer, I guess.
Good job. All right, this one is in regards to Form 4.4A, delivery and receipt of association documents. So this form, we have a very hard time with. The HOA sometimes takes up to 10 business days and require payment for these documents and are oftentimes more than 300 pages. And then she goes on to, we often have HOA that even say that they cannot provide documents any sooner than 10 business days after they are paid for.
Yeah, I know. I mean, it's a problem. That's why I suggest when you get a listing that's in a HOA, be proactive. Try working really hard to come up with these documents right from the very start, because there can be some significant stuff. I know we're running up against that a lot ourselves. And again, having this information early is really helpful. Now, some of our agents are awesome. As soon as they get a listing, they're digging into all this stuff. They're letting their seller understand. Again, this is coming across. This is you as a professional listing agent say, this is something that must be disclosed. It's going to be asked for. So let's be proactive. Let's gather all this information together right now. And then we can check the box. It doesn't exist. So that way we can fully disclose this to the buyer at the point of time when they're asking for this. This document doesn't exist. But get it early. I agree. And if you find, if you're in the course of your real estate transaction that hasn't been gathered early, you may have to extend the time frame for the seller to come up with all these documents.
Okay, the next one, is there a 2-year listing requirement? The 2-year listing requirement, does it also apply to commercial listings?
Great question. I believe 4058 only applies to residential, but I'm not 100%. That's a Nicholas question. I'm not an attorney, and even though I'm not 100% on that, that's a great question, and we need to get back on that.
The referral should be clear that the payment is on the action side only, not what the agent received, as the agent might double side the sale. That's
Yeah, yeah. And that I agree. It needs to be very, very clear. It's only on, say it's on the listing side or the purchase side. It's not on both sides. And that's really true. If it's not spelled out clearly, the referring brokerage may be entitled to both sides. Absolutely.
okay. This one says these forms are great. Thank you. Is there any chance of another class that compares the key differences between Oregon Realtors Forms and OREF forms? I know there was an in-person class. Was that recorded by chance? Or could we possibly have a webinar in the near future? I think that in-person class was provided by OREF, right? Oregon Real Estate Forms.
Yeah, or I know ORF had a presentation earlier this week on their changes. I know at Central Cascade East Association of Realtors, we had a forum that was several months ago, in which we were talking about some of the changes as applied to the Oregon to the NAR settlement and how we were handling that. And we had representatives from both ORF and Oregon Realtors there to basically talk about some of the way Oregon Realtors forms are. This is how ORF forms are. But I don't know. That'd be something that I don't know if Kelly, if you're at all something that would be put together, that'd be helpful.
We can look into it. Absolutely. All right. Let's see. Are the Zillow tour agreements valid in Oregon?
That's an attorney question.
Ah,
That's an attorney question. And you would think that Zillow's attorneys would have drafted that, but I have no way of knowing for sure. I know that it was a discussion with a task force if we should have a tour agreement. And we just shut it down from the perspective that we really think it's the Oregon Form 9.4, the representation agreement is so good. And it's so easy to modify with Form 9.4A. And again, it overcomes, case in point, one of our agents got a floor call from a buyer who said that they wanted to see this property and they didn't want to sign a long-term contract. It was not our listing. So our agent said, look, I can show you this property, but I have to have this form in place. It's a requirement, but I can do it just for this one property. We'll do it just for this one property. So we're totally compliant. We have everything in place. And it just so happened the way she showed that property was so great that that buyer called her up and said, hey, I really liked your style. I want to work with you. So they modified the contract for 6 months. And it was so easy to do, but to overcome the objection just by doing, hey, let's do 9.4 for one property, and you outlined what it was, it worked perfectly. And so for our mind, from the task force who worked at this and discussed this, we thought this was a better solution.
okay, looks like we have 1 more minute. So let me see here. Is the referral form, in the referral form, is there a place to designate for first transaction only and states after the first sale or purchase, the client continue with the receiving broker without referral fee owed? I have not used this form for referrals. Thank you.
And I know that most brokerages, my brokerage has its own referral contract that we use for a long time. I could try pulling that up to tell you the truth. We can all take a peek at it right now. Go into SkySlope. And just go to the library because I just had the deck right there. Okay, so it talks about here to receive a certain figure of the receiving agent's eventual compensation upon successful close of client's transaction. And then again, you can always use the additional provisions section here. They agree to the following instructions. So there's additional things here. So to answer that question, I think you can obviously fill in the blank with whatever is most concerning to you.
You want to share screen and show that one?
Oh, I thought I was. I'm sorry.
You're sharing screen on the last one. I think you'll have to stop and then go back. It's picky that way.
Share my whole screen. Can you see that now?
Yes.
Good. So it's this section right here.
Great.
Mhm.
Okay, there's another one here. Can Oregon Real Estate Forms and Oregon Realtors Forms be used in conjunction with each other? If not, can that be a consideration on the next updates to make it possible?
Very great question. And if they are used together, it's what we call a Frankenstein transaction, and it's terrible. It's not good. If I ever see something like this happen, I tell people we have to use one library or the other, because they're different. They're very different. The things that can be used interchangeably are the disclosures, the seller's property disclosures. Those are written by statute. They're exactly the same questions. They are formatted differently, but those can be used interchangeably, but you cannot mix these forms together. They have different timelines. They have different things. For instance, ORF does not have a section where you can try to remedy any sort of failure to perform. There's a lot of things that are very different time frames. I mean, just the whole things are different. So if I ever see one of these things, and they do come in every now and then, I say, no, you gotta redo it based upon one library. And so you can't mix them together. They're very different.
All right. And then one last, like to see a line added to Oregon Realtors Forms that was taken out of the Oregon Real Estate Forms years ago, that the buyer can do a walkthrough prior to close if they choose. Sometimes they want to, and sometimes they don't. Sometimes things change during a transaction, and at the beginning didn't need it, but the transaction now dictates that we do need to do one. No need to
Great.
respond, but
No, I think that's a great question. And I can tell you, we debated that with a lot. That was one of the things when we were first putting the forms together. We talked about whether or not we should have that as templated verbiage in the purchase agreement. And we talked about it because it is true. It's in certain states that they always have, the buyer has a right to do a walkthrough. We elected here in Oregon not to incorporate that into our purchase agreements, just from the perspective of like, would it become a contingency to the purchase if they walk through and they discover, oh, the house isn't as clean as I wanted, but you never negotiated, but it was not part of the original purchase agreement. We elected instead that if it's really, really important to your buyer, or you as a buyer's agent find it's a thing that is the way you do your business, and you want to encourage this, always write it in under additional provisions, that buyer to do a walkthrough prior to closing. And it's one of those that I think it goes by case, but we did discuss this and we debated it as a task force. A bunch of us as committee members looked at this and we elected not to do it. So again, I understand that it's something that we could bring up again, but it's one of those that it was debated. I do have one of our agents who always writes it into the purchase agreement. It's important for them to have a walkthrough to know the condition of the house. They have a right per the purchase agreement at the point of time when they're reviewing the repairs to see whether or not the repairs have been made. So that's always in the purchase agreement. But true story, we had a buyer, and our seller was in the midst of moving, and boxes everywhere. And this was a buyer who came back over and over and over during escrow to see, to bring in another contract. And this is past the due diligence period. And finally, our seller said, enough, I got to be able to pack up. I don't want them in anymore. And it was a matter of convincing the buyer's agents, like, no, it's not that they're hiding anything. It's just that it's not convenient. They just can't accommodate this buyer any longer getting back into their house. So it's so important to make sure, if that is an issue that's of concern to your buyer, that it is written in the contract. Please do that.
Well, it's 5 after. There is one more quick question. Is that okay if I go ahead?
For me, sure.
Okay. Using the form set separately, using the form set separately does not apply to the advisories, correct? Buyer and seller advisories?
The buyers and sellers advisory, I highly recommend, even if you are so comfortable with the other library, the ORIF library, and these are always risk management tools, but it is mandated. If you read the first paragraph of the purchase contract, it outlines that buyer and seller, and this is of Oregon Realtors purchase contract, it says they have received the appropriate advisories. So you must incorporate those in the purchase or sale utilizing Oregon Realtor contracts. But I advise it, I actually have it as one of my checklists when you take a listing as a seller advisory, then provide it to the seller. So it's an important risk management tool. Like I said, I can't emphasize that enough. It's such a wonderful, wonderful tool that Oregon Realtors have provided for all of us to use.
And the last one says, perhaps you can't answer because more related to ORF forms, wondering why they increased requirement for HOA minutes up to 24 months rather than 12.
That I don't know. I don't know. Yeah, if ORF is requiring up to 24 months, I always think more disclosure is good. So obviously providing access to anything and everything you have, but I don't know if there's an ongoing issue that's been, 15 months ago, that's no longer covered in the minutes. It's probably been resolved, but that's, I don't know. I really don't know.
Okay, well, there are multiple kudos and thank yous and good jobs to Linnea. So,
Well, thank you, everybody, and I wish congratulations to Nicholas. I think Finnegan, what a cute name! Oh my gosh, that's absolutely darling. And here he's over 8 pounds, so that's great too. Healthy baby.
yes.
Yeah.
All right, well, that concludes our session. Thank you, everybody, for joining, and we'll see you next time.
Thank you.
Thank you, Linnea.